Oh, good afternoon, everyone, and welcome to this week's Tea and Tech, our weekly discussion panel looking at what's happening in the tech law world. I'm David Chaplin, editor of Computers and Law, and this week I'm delighted to be joined by Leah Grolman, a member of the disputes resolution team at CMS Cameron McKenna, and a regular contributor to Computers and Law, I'm pleased to say. Martin Sloan, a partner at Brodie's in Edinburgh, specialising in tech law and a member of the SCL advisory board. And Jason Coyne, partner at IT Group UK and well known to many of you, I'm sure many of you have come across him as an expert witness in IT litigation and many other things, I gather. Of course, while we're talking, please do send things through the chat panel so I can lob things into the conversation if you've got anything to say as we're talking. But before we get on to the main event, a quick catch up on some things that are coming up in the next week or two. Firstly, a reminder that on Tuesday evening, Di Davis is to deliver a talk on why Brexit made IT law bad for business. That's on at 4 o'clock, and I'm sure will be provocative and informative. Also, the day before, the SCL student group is hosting an event to celebrate International Women's Day, looking at women leaders in tech law. And that is on at 6 o'clock on the 8th of March. Also, just to point you towards a couple of things we published this week on the website. We published news about the Law Commission's call to reform the law around intimate image abuse, including a suggestion to make deepfake pornography a crime. There's also a report on 2 cases concerning streaming, copyright and ISPs. Recommended reading if you don't know about stream ripping and crypto lockers. And yesterday, we published news about the CMA's announcement of an investigation into the Apple App Store and whether it is anti-competitive. And this is the subject of our first talking point today. And Leah, you're going to give the listeners an idea of what the regulator is looking at and why.
Sure, David. So I noticed this pop up yesterday when David pinged me an email, and I reared my head from work and got very interested. The investigation opened on the 3rd, actually, and runs through to September this year. The Competition and Markets Authority is investigating Apple in terms of whether it is using its dominant position in connection with distributing apps on Apple devices in the UK, although similar sort of complaints have been launched by the same app developer who has spearheaded led to this investigation being brought in Australia and in the US as well. And so the CMA looks, as it does in all of its market investigations, at whether the conduct that Apple, and we'll get to it in a minute, the conduct Apple is engaging in is having adverse effect on competition. And in particular, they're looking at Apple's terms and conditions imposed on developers using the App Store, and things like stopping developers from using their own payment processing services. So if you're in an app and you want to make an in-app purchase, that's got to go through the Apple payment system, and whether Apple's charge of taking a 30% cut of all purchases made on its payment systems is unfair and is having adverse effect on competition in the distribution of apps. And so this all came out of complaints and sort of a lot of a groundswell of support actually for Epic Games, which develops Fortnite. I've never played Fortnite, but I've seen sort of YouTube videos on it because it's quite a popular game, and apparently it's been downloaded last year, so a number of months ago, had been downloaded over 250 million times from the Apple App Store alone. And this game is also, it's one of those battle games that you can play with other people, and it's been downloaded, it's on PS5 and it's on a whole lot of different consoles. So that's pretty incredible. And I mean, that's the nutshell of what they're looking at. Fortnite sort of provoked this, but they provoked Apple to ban their game from the App Store by announcing to users that they could buy current game currency off outside of the app on Epic, direct from Epic Games, not through the App Store, and use that in the game at a lower price than what they could in the App Store. And Apple went, great, you're banned from our App Store, and they haven't been reinstated. Yes, and I think the Google Play Store has done the same thing. I'm not as familiar as with the Google App Store, but I think that there are similar concerns there.
I think the Google App Store is less stringent when it comes to imposing what you can do and what you can't do than the Apple Store. So I think that might be why the Apple Store is the centre of this investigation at the time. So, Jason, Martin, have you got any thoughts? What do you think this is the right thing to do? Jason, you're champing at the bit there.
Yes, I mean, one of the differences is that with an Android device, you can actually connect to multiple different app stores. It's not similar. It's not similar to the Apple system where you can only get apps from the Apple App Store with an iOS device. I mean, from a security and a quality perspective, I think Apple are right and on firm ground that applications that are going to go on their device should only be procured from their app store. It reduces the risk to their users. They can ensure there's no backdoors or malware, and that the applications perform as Apple would want them to perform. So I think that developers and users would support that. I think the difficulty is the follow-on purchases, as Leah says, that essentially you've got to do the follow-on purchases, whether that's in-game currency or whatever it might be. That's got to go through Apple's payment gateway. And I currently can't see the value that Apple are providing in order to insist on that. That's the way it's done. So I think that's the weaker ground for Apple on that point.
Yeah, I agree in that. I think, certainly from a quality and security perspective, having a single app store where everything is vetted certainly is. I use an iPhone and most stuff comes through and it's fine. And you hear stories about more buggy software on Google, on Android, but the issue about where the payments go seems to be harder to justify. But as a matter of competition, I suppose the question here is, yes, all this is out of control, but actually what is the output of this? Is it actually that there's less control and less choice? Because the App Store is a marketplace. So is there actually a disruption to competition? And that's the thing I think the CMA is going to be looking at, because there will be different people can put different games in there, different apps that do the same thing. There's natural competition in terms of how much they charge for that. So is there actually an increased cost to the end consumer here? And that's the bit that it'll be interesting to see where the CMA goes in that, in terms of what conclusions they reach as to whether they can see actual distortion in the market.
Is it the level of royalty due as well that might be a problem? Because it's 30%.
It is, but it's 30% on all the platforms, because it's 30% in the Play Store, it's 30%, if you look at all the sort of big marketplaces for these sorts of things. And there does seem to just be everyone is charging the same, which is in itself is a problem, but also makes it harder perhaps to attack any one alone rather than all of them together.
And that's why I think, I think the 30% can be justified if what's happening is you've got some Apple developers looking at how compliant your code is in your application and how it will perform. There's clearly some value there. But for the aftermarket purchases, they are simply processing it as I understand it. And I think that's where there needs to be a different margin applied to that, or an allowance that can be procured outside of the Apple payment gateway.
I had a comment in here from our web producer, Simon. He's just throwing in this one as well. It's also impossible to submit an application to the Apple Store without using an Apple Mac. I don't know whether that's relevant at all, but it just shows you that you've got to buy into the Apple ecosystem and to be able to put something up on the App Store, and that might be a problem. Does this move tell us, though, anything about the direction of what the Competition and Markets Authority is going to be doing in the next few years? Because they've just set up their digital markets unit, haven't they? And is this a sign that they are after the tech giants, let's say?
I think yes. I think that's the direction of travel. I mean, this comes off the back of the report mid last year that they released about online platforms and digital advertising, and they made recommendations, from memory, in that report about a sort of new regulatory regime for those platforms that was going to be more competition friendly, or more kind of pro competition. So I think this is the direction of travel, and this is part of that broader push to ensure greater competition in what have become very big platforms.
Yeah. So I mean, so we're going to be watching this a lot more, this space, aren't we? I think is the answer. But yeah, it doesn't lessen the frustrations we've got putting things on the App Store at the moment. Okay, moving on. The other headline news from this week, obviously, was the budget. Now more mainstream, obviously. There are some elements there of interest to the tech lawyers, and I thought it might be useful just to bring people up to speed with what's out there. Martin, have you got some? You noticed one or two things in the budget that might be of interest to us?
Yeah, and I think this is quite a tech-focused budget. That clearly the tech sector is something which was spoken about a lot in the budget, and it's certainly, from what I've read, what I've heard from other people, in terms of their views, is that it's been pretty well received in terms of what's in there. There's a lot in there around visas, and new visas for expanding for tech entrepreneurs, scale-ups and things like that, improving on that, which is good.
What? Yeah, the scale-up. What is a scale-up? Could you define one? I didn't grab that.
Yeah, I'm not sure how they're defining it for the purposes of the new program, but they do seem to be looking at high growth companies in the tech sector and looking to see what they can support that entrepreneurs coming to the country, which is all good. I suppose that the flip side of that, though, and one of the things that certainly if I speak to contacts in universities, that one of the concerns they have is around students coming through. So it's all very well having an entrepreneur come through, but actually the people who come through universities and who graduate and then stay in the community, and I live in Edinburgh, and Edinburgh University's got a great reputation for its technology, its computing science courses, and it's hugely dependent on EU nationals and overseas students. And I think one of the concerns there is just around ensuring actually you still get those students coming through, and they're part of what actually makes the sector breathe, because they're the people that are coming through. It's not just about students from the UK. It's a mix, and bringing that together. The postgraduate courses are sort of a lot of them are overseas students, and that's the thing I think is still not quite bottomed out yet. So it's great to have these new visas, but I think they're only one part of the jigsaw.
Did we get much detail on? Did you find any detail about how this scheme is going to work?
I've not seen the detail of it yet. No, but beyond the headlines. So.
No, neither have I. I had a quick look, and I couldn't find the detail of the scale up. I think it's in a Tech Nation report from a few months back that they're trying to take on some recommendations from that. Jason, you noticed some things around fraud as well, didn't you?
Yeah, so it looks like money's been allocated to HMRC. That's both to look at protecting the investments that have been made, within the furlough scheme and the self-employed income support schemes, to make sure that fraud doesn't increase within those areas. But there was also a reference in there to how the same scheme could start to look at fraud where fraudsters are posing as HMRC. I mean, quite a few listeners may have got the text message after submitting tax returns saying that there's a dispute being raised, and click on this link to pay a certain amount to settle it. A lot of fraudulent emails and texts like that. So it may well be the case that HMRC are setting up some sort of cybercrime unit to start investigating this as well, which I think is great. I'm just not sure how well HMRC are geared up to handle that investigatory side. Cybercrime could well be the case that they might look to partner with the private sector with that, or potentially invest on systems and processes internally to be able to handle that. So there could be another big public sector computer system being implemented within HMRC. something to look forward to in the years ahead.
Yeah. So would what sort of problems do you think they'll face if they are trying to investigate these people who are posing as HMRC? I mean, it's
well,
from
yeah,
a forensic point of view.
Yes, well, I mean, certainly, you know, historically, everything that HMRC have done has been based on either a company that has a UK entity, a UK registration, or is based around the national insurance number that can identify somebody. So that side of it should be reasonably easy to manage with some almost like a CRM system, you know, customer relationship management system that tracks everybody. But then with the cyber fraud, typically these people committing will not be based on UK soil. They will not have any of the elements to identify themselves, such as a national insurance number. So that you could be tracking literally millions of people with very little information to be able to identify themselves. And I think that's where the cost of that process will come in. Unless they start to use the public sector, who you know, there's a number of organisations that will have the knowledge to be able to tackle some of that.
Leah, did you see anything of interest that caught your eye?
I got I was interested in the visas. I mean, one thing I'd say is that I think it's essential to have. I know we're thinking about it the other way around, of students coming through. I mean, to get the students to come over here, their options for after university are often just as important as sort of offering the courses, because if you can't get a visa easily afterwards, I mean, visas are a big thing in Australia, in the news, and changes to you know, how easy is it after you've done your degree overseas to stay in that country, because you're on a student visa and then immediately you're no longer studying, and in many countries you're out. So I mean, I think it's kind of a chicken and an egg thing in a way. Having the visas in place is really important to attract people to come and do the courses that are, you know, market leading, world leading in the UK. So that was the only thing I was focused on the visa point as well.
The one other thing I noticed, and they've gone back, they had Lord Hill's published a review on the same day about city listings. I know we're not company lawyers, but just some thoughts on this. That apparently they want to loosen up some of the listing rules so that you can have an IPO with fewer shares on offer, and also this dual share structure. So they're imagining that you can create sort of a Mark Zuckerberg super shareholder who retains all control as a means of getting people inward investment for tech companies. Anybody got any thoughts on that? Whether it's a good idea? To my mind, it's not a good idea, but do others think that is a good idea and what we should be doing?
Is that coming because another jurisdiction allows that, and we want to compete by having all the flexibility?
I think that's the reason why, is they want to try and encourage investment in tech companies, and they want that wonderful word unicorns. They like unicorns, don't they? I think, yes. And they want more unicorns. And one of the ways in which they think they can get that is by allowing the founder to retain more control. But I'm just not sure that's a good idea. But I just wondered whether anybody had any thoughts on that.
Well, I mean, I did wonder. One of the other things was mentioned. It's not exactly the same, but it's to do with the Future Fund, isn't it? Where they were talking about life sciences and tech, and this 20 million plus project size, where funding's available, and there's going to be match funding. So UK government's going to take a share, and it's expected to be matched by a venture capital firm. So I think that, you know, trying to alter the structures or influence the structures, you know, of shareholding within companies is quite interesting.
Yeah, but I mean, it certainly seems that they like to put the headlines are, we are tech friendly and we're trying to get investment into technology. But did they miss a trick? I mean, there's been a lot of talk about a digital services tax or something like that. And last week, in the same week of the budget, I noticed that the state of Maryland in the US has introduced a digital ad services tax. Did they miss a trick? Are they workable? Should we be going that way? Because obviously we need to raise funds to pay for the coronavirus.
I think it's very difficult to do these things on your own. whether you are a single state within the United States, or whether you are the UK, to try and do something not done in conjunction with other countries, it's very difficult to implement something that someone's not going to find a way around. And we've seen various initiatives where the cost just gets passed on to the consumer. It doesn't actually have an effect, or people will restructure in a way. So I think the challenge here is it's a very difficult thing to actually solve. I think everyone can see that there is something to be resolved. And particularly if you're looking at digital versus bricks and mortar, retailers competing against each other, clearly there are challenges around things like business rates and how much you pay for a high street shop versus a shared and industrial unit. But it's very difficult to actually solve some of these things without totally restructuring things, or looking at a broader sort of international scale as to how you approach it.
It will be very interesting to see what sort of returns they actually get against that tax, really. It might work. I don't know how you'd measure it. I don't know how you'd monitor it. I think you've got problems with auditability from it. But I agree. It's forward thinking, and it's looking at the right sort of area. I just think the execution is going to be incredibly difficult,
especially when you're on your own. You've struck out.
Yeah.
This is the United States of America. You're one state in the United States. It does strike me that there's going to be a lot of problems trying to quantify it. As far as I'm aware, I did a brief read about this new tax. It's on digital ads revenue, and they've got to sort of self-declare what they've made out of digital ads. Where have you made that? Out of what businesses? Who knows?
Yes.
I don't know how you'll be able to really tackle that, but the idea is something that has rumbled along, and it seems like some people are taking it seriously, and we'll have to see how it goes, won't we? Leah, have you got any other thoughts on that?
I was just thinking it's nice to have someone else be the guinea pig, and we can adopt it if it works.
It's a beta project.
Permanently
in beta, probably.
I mean, the same way that states like Arizona do, testing of self-driving cars, and have the first kind of legislation and regulatory bodies and that kind of thing. I think it's helpful to see sort of tested in a microcosm in another jurisdiction, and we can adopt then what works if it does work. So it's really interesting to see that they've done that. I think they're going to kind of stick out a bit for doing that, and we'll see what comes of it. But watch this space, because there are lessons to be learned from those jurisdictions doing those things.
Yeah, I think we'll move on now. The other thing, something we reported about a week or two back that we want to look at today, was consultation on digital dispute resolution. I forgot what their name is now. The UK tech law body has issued a consultation on new dispute resolution rules aimed at arising from novel digital technology, is what they described it as, such as smart contracts and cryptocurrencies. Martin, you can give us a little bit more detail on that. I think you've had a read around it.
Yeah, so this is quite an interesting one. This is the latest thing to come from LawTech UK, which has been around for a couple of years. And LawTech UK was the body which came up with the legal statement on crypto assets and smart contracts last year. Or 2 years ago now, I think it was, possibly. Actually, I lose track of time with COVID.
Yeah, I think it was.
I think I missed a year.
Yeah.
So it must have been back in 2019. One thing, LawTech UK, although it's called LawTech UK, it's not really LawTech UK. It's more LawTech England and Wales, in that it doesn't look at the other jurisdictions in the UK, so nothing in terms of Northern Ireland or Scotland. And I'm not just raising that as someone who's Scottish, but actually because there is actually an issue here which I think is overlooked in some of this stuff around private international law. But what this was about was how can you quickly resolve disputes where you have disputes relating to digital assets, you've got smart contracts, things that are on the blockchain, and how can you then implement that decision on the blockchain once you've resolved it. And so what LawTech UK has come up with is a set of rules for consultation on how this might work. And it's basically an arbitration or expert determination scheme. So this is done under the Arbitration Act, and the idea is you have a pretty simple set of rules that can just be incorporated or referenced in your contract terms, or in your system, whatever it is, dealing with crypto assets or digital assets. And what it does do, which is quite interesting, it tries to deal with some of the real challenges here, which is, I suppose, firstly, you will have potentially small value assets here, so you want to resolve the dispute quickly and not incur a lot of time and money. You might not know who the other party is, so you might be transacting anonymously with someone and not know who they are, but you get into a dispute with them. The output of this process is binding, so it applies automatically. And what's quite interesting is they propose that the tribunal will have the power to actually then implement that, so they can, to the extent they're able to, they can modify, cancel, change a digital asset, or they can direct a third party to do these things. So this is potentially quite a powerful mechanism if people engage with it and build on it. And the SCL, the Society of Computers and Law itself, is referenced in the document. So it suggested that the SCL would appoint and run the panel of arbitrators that are used for it, which I guess builds on the SCL adjudication scheme, which has been going for a couple of years. I mentioned at the outset that this question on private international law. So one of the things that one of my criticisms of what they did a couple of years ago, that was very much looking at just the English legal system and not looking abroad, whether that's the US, France, Germany, Scotland, wherever, and actually only looking at how English law treats these assets, but not perhaps thinking as much as they should do around the private international law issues here. So with a digital asset, how you trade in it, how you grant security over it, how you sell it, is governed by the laws that apply to that asset. And that's not necessarily something you can agree by contract. You can just agree we're going to apply this legal system to it. And so one of the things I think would be interesting with this scheme is how it deals with some of these challenges, because if you have, say, a transaction between someone in the States and someone in the UK, how will this arbitration scheme deal with that if it's an issue about title to that asset or what can be done with it? And that I don't think is really covered in the paper as to how it will actually operate in this sort of level. It's very much a scheme for resolving disputes, but I think there'll be some disputes which I don't think necessarily this will be the right forum to deal with them. I might be wrong in that, but certainly for a first read, that was one of the things that came out from me. The other observation, it's saying that you would raise your issue, you would then get the arbitrator to look at it, and then they'd expect a response from the other side within a few days and resolve this within a month. But that's quite a short period of time to resolve something that's potentially quite complex. So, in terms of getting access to evidence, sharing that, is that feasible within those timescales? I mean, I don't know. I'm not a litigator, so I'll defer to Leah on this. But I think it's got really good aims, but I'd be interested to see how it actually, would work in practice.
Leah, have you got anything?
I've never seen a dispute resolved in that period of time.
That's because it's not using this scheme.
I mean, that could be because we're not using the scheme. I mean, I think on the evidence point, I didn't quite understand, and perhaps I'm missing something, but I didn't quite understand how you could have dispute resolution where both parties remain anonymous, and yet there still be provision for disclosure and evidence. And what is the arbitrator going to look at that in a void, or kind of redacted? And if so doing, all that kind of redaction and that kind of thing, that's going to take itself more than a few days often in these kind of big contract disputes and that kind of thing. So I mean, I think it definitely it's something that should be used by people who think it will resolve their particular disputes, but it's going to be really fact specific as to whether it's suitable for you. I mean, in the same way as the SCL adjudication scheme, I think one of the interesting things will be, how do we get people to adopt this and to give it a go? How do we get the sort of the guinea pigs to put their dispute through it and to have sort of success stories about it, to then get to a position where people in transactional roles are recommending this as a neat way of ensuring that you've got a clear cut, efficient dispute resolution procedure in your contract. It'll be really interesting to see where
Jason, obviously you're deep into the forensic side of all this sort of thing. Do you echo Leah's doubts about how you can actually litigate when you don't know who the parties are?
Well, yeah, I mean, I'm not sure whether that would be the sticking point for me, really. But that said, the task that I undertake is often very dependent on the quality of the material and the disclosure that I'm given and the access to the systems that the dispute is about. So, you know, in broad terms, I think it's good that we look to reduce or remove any latency in the dispute process. I think that's good, and I think you know, it's human nature to sort of fill to the time that's available, and so I think there is days or perhaps weeks that can be shaved off the current process, and I think there was an acknowledgement in there that if more time is required, then the parties can ask for it, and more time should be given. So that the quality need not suffer, but I think it's very dependent on the types of disputes, and it's that I'm not clear about yet, about what types or the nature of disputes would be. So I'm very interested to hear more about it.
So do you think, I mean, one of the questions they've asked in the consultation is, do you think there's a need for a new arbitral process for these particular types of disputes arising from cryptocurrency, smart contracts, things like that? Obviously, we were sort of talking beforehand about the various news stories this week about Grimes selling NFTs, non-fungible tokens, to the ownership of or sort of ownership, we don't quite know what, of a piece of art that she's put up online. Is that the sort? Are those the sorts of things that are driving the need for this? Do we think there's a need for particular rules purely for digital technology disputes, let's say, or well, can we deal with them in what we've got already?
I mean, I think you could certainly deal with it with what we've got ready. I mean, it would be good if, you know, if it's signed up for, and you know, we could be dealing with a dispute like that within days rather than within months, and in a similar way to how expert determination works, the parties agree to be bound by whatever the experts or the arbitrator decides. So, you know, it whatever the award is, it's executed straight away. So I can see that. So I can see the benefit. Yes, I think I can see the benefit. Whether it can be achieved in the current framework, I think it's possible, perhaps with modest modification.
And would you welcome? I mean, as an expert witness, I mean, would you rather be involved in those kinds of dispute resolution procedures than going all the way to the IBM and the IBM co-op litigation?
Well, I think what will probably happen with the fast track dispute resolutions is you'd probably look more to the single joint experts rather than an expert either side and then arguing about it. You know, reports in sequence and then joint reports, because that takes up a huge amount of time and delivers a huge amount of value to the court. I think that the single joint expert would probably be the way that these fast tracks go. So one party would look at both sides and produce one report, and essentially the arbitrator would then consider that report. So there wouldn't be opposing sides, if you will, from an expert point of view. I don't think I'd welcome that, because historically joint expert instructions have been incredibly problematic, because you can't get clarity over what the instruction is, because the opposing parties want to instruct on different things, and it becomes incredibly difficult to get it. Now, if it was the arbitrator that decided what the instruction was rather than the parties, then that might work.
I agree. There's going to, I mean, you just front load the argument. You know, you may not be arguing, the experts might not be arguing with each other, but the parties will argue until the cows come home on who the expert is and what their instructions are. So I think yeah, I can see that it may not be as efficient as desired, having one joint expert, if that's the way that this envisages expert evidence.
We've just had a comment come through from one of the listeners. Are we influenced in our thinking by the fact that in the UK we are used to an adversarial dispute resolution process, but those in a civil non-adversarial system may be a little bit less sceptical? Is that true? And obviously these rules may attempt to apply to a non-adversarial regime, might they?
Yeah, I think that's a good point. I mean, as soon as you say, well, could the arbitrator give the instructions to the expert? That's a foreign language to anyone in an adversarial system. But you know, if I was saying that to my friends in the Czech Republic, well, that would be just normal. That's just the process of dispute resolution there through the courts. So yeah, absolutely, we're viewing this through a particular lens that we should probably try to separate ourselves from at some point when analysing the benefits of this kind of regime.
The other thing to bear in mind with this scheme is that it's very much part of a strategy of trying to make the UK an attractive place to set up your crypto business. So this is about providing the framework in terms of saying the law saying, yep, we can deal with these assets, and we've got a system to resolve your disputes as well when they come along. And I suppose part of our challenge with all this is that we're not used to the volume of disputes yet because they're just not happening. But in terms of providing that framework going forward and advertising the UK is a good place to come and set up your crypto business, going back to what you spoke about with the government and the budget earlier, it's all part of that wider message, I think.
Interesting point. Look at the time, we are slightly overrunning. Everybody's tea is going to be going cold, but just before we leave, I gather, Martin, you might be looking for a new job.
Well, I did look at it, but no. So it was interesting. This I suspect, unlike all your previous weeks, David, there weren't many data protection stories this week to look at. Whereas I think last week you've had quite a lot, but the one that did catch my eye was the advert is up for the new Information Commissioner in the UK, and I think it's really interesting in terms of setting the tone what's going to happen over the next few years in terms of regulation, because the current commissioner has been criticised by some people for being perhaps a bit too focused on big projects and not the actual mundane day-to-day enforcement. But whoever takes this on is going to very much set the tone in terms of what's happening going forward. So we've got ad tech, we've got AI, we've got all the buzzwords where data is involved. But we've also got things like post-Brexit, to what extent is the Commissioner going to align itself with what the European Data Protection Board is doing in terms of changes to guidance? There's nothing in the law that doesn't allow the Commissioner to say, actually, I'm going to just follow that guidance. Doesn't have to, but they could still decide to align. And a lot of businesses, I think, would welcome continued consistency. But you may find you have a Commissioner who wants to go their own way on things, and we could see some changes. So that how would they deal with the CMA? We talked before about the Competitions and Markets Authority and what they're doing in terms of regulating the tech space. And that, again, is another really important interface.
So forward. Do you think there will be a political element to the appointment? There shouldn't be, but they'll look for somebody who's sort of robust in being independent from Europe, or?
I don't know. I guess it depends. It depends who applies for the job. But I think it will be really interesting to see, who gets that, what their background is, and where they come from, in terms of how they might take data protection regulation over the next few years.
They're due to take up the post in October, I believe. Is that right?
I think that's right. Yeah. So you've got to the end of the month to put in your application if you're interested.
Okay, there we go. We're doing some recruiting for the ICO there. I think that we'll have to draw it to close, as I say, because we advertise this for half an hour and we always overrun a little bit. But I'd just like to thank you for that tremendous discussion. I really enjoyed that. Covered quite a few areas there today. Obviously, we only skirted around a few of them, but it's great to cover what we can. If anybody listening really appreciated what we did today, please go to buymeacoffee.com/SCL, and you can leave a little appreciation, buy us a coffee there. Any money that's raised goes towards our student initiatives, including the Student Bites event that's coming on Monday, so it helps to fund that. You may also want to check out previous Tea and Tech sessions available on the dedicated page of our website, scl.org/tea and tech. Next week, I'll be joined by Shabana Iya, Toby Crick, and Minesh Tanner. So I hope you can join us again then. And in the meantime, tick off another weekend in the lockdown calendar. Okay, thanks, and see you next week.